Let's now speak to the head of strategic litigation and gender equality programs at Lawyers for Human Rights, Kayan Leung, who now joins us. Kayan, good evening. Thank you so much for your time. Really do appreciate it. Today we had an extensive debate in the court about the normative mechanics of consent. The current jurisprudence in rape trials is that if a person A accuses person B of rape, the onus and the burden of proof lies on person A to prove, that is to say the victim, to prove that there was no consent. And oftentimes to prove that, they either say, I said no, and here's how I can substantiate that, or there must be some sort of presence of physical coercion and constraints to substantiate that there was resistance. But in an instance where there is peritraumatic responses, we heard in court today, which, Justice Majid had noted to be a learning moment for him as a justice on the bench. We learned that sometimes victims are so shell-shocked about the moment and the trauma that they're not able to verbalize a no, and neither are they able to present any physical restraint. That doesn't mean that the absence of the no means that they were not raped. How does the court rationalize that complexity, or how should the court rationalize that complexity of what consent truly is, what it looks like, or what the absence thereof looks like?
Good evening, and thank you for the invitation. I think this is a really important question, and to maybe frame it, why this court matter, this decision and judgment is so important for our country is that sexual offences remains one of the most serious challenges in our country. In fact, rape in particular is the most reported crime in this category. Between 2023 and 2024, of the 53,000 sexual offences recorded, approximately 42,000 of those were rape cases. And yet, despite these high numbers, we're seeing that so many of these rape cases that are reported don't progress after being reported to the police. And there are a number of reasons why that is. But one of the challenges, as you correctly identified, is that there is currently this legal position because of the law as it currently stands, where an accused can still avoid conviction if they claim they believe that there was consent, even if the belief was completely unreasonable. So in cases of sexual offences like rape, there's 4 elements to prove. There needs to be, firstly, an unlawful act, secondly, sexual penetration, third, the lack of consent, and fourth, intention. But the crucial point here, or the critical point, is that intent currently is judged by the subjective test, which essentially asks, was it possible that the accused truly believed that there was consent? And that's where the controversy lies. That the argument is that we should not be looking at this still as an offence when there's an accused in these types of cases of sexual violence. And that's why this case was brought forward by the Embrace Project, supported by the second applicant, Ms. Holzstracher, and of course the Centre for Applied Legal Studies, who is trying to argue for a different type of relief. But the exact evidence that you're wanting to interrogate, which is a very important perspective, which came from the Centre for Human Rights and the Psychological Society of South Africa, represented by Lawyers for Human Rights, is that we must emphasize that when survivors experience what's called peritraumatic responses during rape, these are hardwired neurobiological reactions that leave victims frozen. They're unable to resist or even verbally express non-consent. And this has never been considered in our courts before in terms of our approaches to interrogating intention and consent. And the research shows that rape survivors are more likely than victims of other violent crimes like robbery or assault to respond passively, which means that in court, when the defense of mistaken belief of consent or the subjective test where I thought there was consent, but even if it was unreasonable, is raised, it unfairly does penalize those survivors who can't actively fight back because there's an expectation of them to behave in a certain way. And so these experts argue that unless we take our laws as it stands into account, this medical research, that there is well-established psychological realities, we're completely risking ignoring lived experiences of survivors.
Yeah, and there was an interesting debate in court, which seemed to be a subtextual debate rather, interrogating the tension between tacit consent and enthusiastic consent on the one hand. I mean, that's not the language used in court. I just want to give it more specific language here. And of course, there was a reflection, parenthetically so, on the ConCourt matter, which is from the Makhanda High Court, where acting judge there, Thembeka Ngcukaitobi, had penned the argument that tacit consent is reasonable consent in an instance where a perpetrator would claim that, look, I was under the impression she had said yes. And that brought into the debate the idea and the of subjective or cultural relativist point of view around consent and how courts evaluate that. It's a really complex debate, but why is it that the court need to be able to make clear here the distinction between tacit consent as not being sufficient and why enthusiastic consent, as Nasruddin had argued there, Advocate Nasruddin, should be the standard. Enthusiastic consent, the active presence of a yes, should become the standard. How would that change how we evaluate rape matters?
Well, I think the biggest change is that we would start having a different type of discussion of sexual consent, because in the ConCourt matter at the SCA, it actually reversed the decision of the acting judge in Kaitobi at that point. So this debate about tacit consent and unpacking that consent in one sexual act does not necessarily mean you're consenting to all ensuing acts following that. And it really does open up the discussion for people entering into sexual activity or sexual relations to really have agency to properly negotiate. And we have to acknowledge that within our times, things are changing. I mean, decades ago, marital rape was not recognized as a crime, and yet now it is. Or the fact, most recently in the ConCourt judgment, just because you consent to one conduct does not necessarily mean you're consenting to everything, and that is just simply recognizing a person's bodily autonomy and agency, and it really does open the discussion for having a different type of discussion on sexual consent.
Yeah, and certainly empower judicial officers much differently in their ability to use evaluative tools and analytical tools in looking at the complexity of rape. We're going to have to leave it there. Kayan Leung, thank you so much for your time and your insights. Really do appreciate it, representing their lawyers for human rights.